if you have an employee that's an organ donor, you're required to let them take 30 days of paid time off. A lot of people don't realize that, but not a lot of people are organ donors. But just in case you encounter this, what you need to know is that you have to give them 30 days paid time off. The new law now also requires you to give them an additional 30 days of unpaid leave as well. Domestic partnerships previously were defined in reference to the person's gender, the same sex or opposite sex. Now the concept of gender has been removed and it's defined as between any two adults over the age of 18. The CFRA, for those of you that have any relationship with airlines, you need to know there are different eligibility requirements that now extend to airline employees. More directly to all of you, what you should know is that the California agency published a new CFRA medical certification form that removes references to gender. So if you are dealing with a medical leave and it's qualifying under CFRA, it's not a bad idea to use the state form that's published for that purpose to give to a doctor. Probably more significantly, more directly relevant to all of you is a change that was adopted by the Department of Labor as it relates to FMLA. So the Department of Labor, the DOL, published an opinion letter, which is guidance for all of us on how to interpret FMLA. The reason that this opinion letter came out was because there was a case in the Ninth Circuit called Streba versus Foster Poultry Farms, an employee who during her employment with the company had taken FMLA 15 times. She went out of the country to assist an ailing family member. Told her HR manager, I need to leave, I need about 2 weeks to go take care of my aunt or a relative who was very ill. Clearly qualified for FMLA, but the employee said she wanted to use her vacation, didn't want to take FMLA leave. And the HR department processed it that way as a 2-week vacation. So the lady leaves and doesn't come back. And when she didn't return on the day that she was scheduled to return, they had a 3-day no-call, no-show policy and they terminated her. She sued them and said that she was clearly on FMLA protected leave because she qualified. It was to care for a seriously ill family member. The court in the Ninth Circuit ruled that the employee had the ability to communicate that that's what she wanted. She chose not to. She affirmatively said she didn't want to take FMLA leave. So the judge ruled in favor of the company. Well, the Department of Labor, the acting director of the Wage and Hour Division, received a question along these lines. Can an employee essentially waive FMLA leave, and can the employer let the person, for example, use up all their paid vacation or paid sick leave and delay the designation of the FMLA leave? And to, I think, a lot of people's surprise, the Department of Labor acting director of the Wage and Hour Division said no, that the law actually, the regulations specifically say that the employee cannot waive the protection under FMLA. The reason for that is probably to avoid situations where the employer pressures the employee not to take FMLA leave. I'm guessing that's why that's in the regulations. But anyway, the Department of Labor said that you cannot delay designation of the FMLA qualifying leave, even if the employee says that's what he or she wants. And you have to give that designation within 5 days of being on notice that the person qualifies for the FMLA leave. I have to admit that until this came out, I routinely would tell my employees, you know, if the person wants to take sick time, you can have them take sick time, and then when they tell you that they want to take FMLA leave, or if they run out of sick time, then designate it as FMLA. I'm changing that advice in light of this because that's clearly not the way the agency anyway is going to look at it. You also cannot designate more than 12 weeks as FMLA leave. I don't know why anybody would do that, but that was one of the rulings as well in this Department of Labor opinion letter. So be careful with your FMLA. If somebody qualifies under FMLA, just like months harassing me, but I don't want you to do anything about it. Now going forward, when someone says, I need to take time off because I'm having surgery, but I just want to use my paid sick time, you say, you're welcome to use your paid sick time, but we're going to designate it as FMLA because we have to. Once we're on notice, we have to give you the designation, and it'll run concurrently with your paid sick leave. Beginning on July 1st, 2020, an employee who takes paid family leave, a person who qualifies for that leave, those of you that don't know, it's a state benefit that you have no control over, it's whether they're eligible or not. They now can get 8 weeks instead of 6 weeks of replacement benefits for wages that they lose for qualifying leave. The one thing about this that I try to mention whenever I'm talking about paid family leave is that it's not creating a right to take that much time off. If you don't have a policy that applies to this type of leave, it doesn't create one. If either the statute or a policy allows for qualifying leave for these reasons, then they get the benefits.